is not in the case. I thought the person was holding your brief.
My lord, the case was not called. We did not hear the time the case was called.
Okay, please, can you call, let's start all over again. Can you call the name of the case? Explaining they have not heard the
actual case. Yes.
Can you unmute yourself? Maybe you are muted.
Yes.
Okay, go on then.
To do this, my lord, MH Outer, I humbly announce my appearance for the defendant. Thank you, my lord.
Okay. Can you announce your appearance, the prosecuting counsel?
Yes, madam. My lord, I am A.P. Muhammad, DL, announce my prosecution.
Secretary, my lord, MH Outer, I humbly announce my appearance for the defendant.
We have heard you the first time, counsel.
My lord?
I said you announced appearance a few seconds ago.
Okay, thank you, my lord. Thank you.
Judgment.
As per process.
The defendant, Ebenezer Oje, was arraigned before this honorable court on an amended 4-count indictment. At Correctional Center, Mr. Outer, can you hear me?
Yes, my lord. Clear and well, my lord.
Thank you. On a 4-count amended indictment contained in a charge dated 4th February 2022 and filed 15th February 2022, and his plea taken on the 2nd day of March 2022. The defendant pleaded not guilty to the 4-count charge. I'll skip the submissions of counsel, etc., and the testimonies of the witnesses because it's embodied in the judgment. I'll be reading it alone. Now, in criminal trials such as this one, it is the duty of the prosecution to establish the guilt of the defendant of the offenses charged beyond reasonable doubt in order to secure a conviction. See section 135, 1 and 2 of the Evidence Act. On the burden, I think the ruling is quite on the burden of standard of proof in criminal cases and ways of proving the commission of a crime and guilt of an accused person, the Supreme Court held in Arigbagbola Awoshika versus State 2018 LPLR that it is well-settled principle of law that an accused person arraigned before any court of law is presumed innocent unless and until he is proved guilty by his accusers beyond reasonable doubt through credible and reliable evidence. See Olayinka Fulanu versus the State 2010 and Okoro versus State 1988, Bakari versus State, etc. Once it needs to be added that the burden of proof does not shift. Once there's the slightest doubt in the mind of the court, such doubt must result in favor of the defendant, who should subsequently be acquitted by the trial court. See Alonge versus IGP. Proof of the guilt of an accused person by the prosecution must be done through any of the listed methods, namely the voluntary confession of the accused person, 2, through direct, credible, and reliable eyewitnesses or victim of the offense account depending on the circumstances of the offense, and 3, through circumstantial evidence pointing or focusing on the guilt of the accused person, that he was the one or one of the accused persons who committed the offense charged, and by no other persons but him. See IDO versus State, 1986 to NWLR, Emeka versus State, 2001, Supreme Court, Ebogonomi versus State, 1993, 7 NWLR, etc. In Mohammed Latif versus the State, 2018 LPLR, the Court of Appeal per Mohammed Ambi Usi Anjuma Jesse on whether proof beyond reasonable doubt means proof beyond all item of doubt, and how is it attained, held that it is tried in law, that the requirement that the prosecution must prove the commission of an offense beyond reasonable doubt does not mean beyond all item of doubt. All that is required is proof that will reasonably fix the accused person with the commission of the offense. Such proof must be by compelling and conclusive evidence. See Adewale Joseph versus State, 2011, 6 SCNJ, Rabi Ismail versus the State, 2011, Adebayo versus State, 2008, State versus Akpabio, 1993, etc. The case of the prosecution against the defendant, as laid down in the 4-count charge, is that the defendant is standing trial for the offenses of being found in possession, under his control, and transferring ammunition of AK-47 firearm and 226 rounds of live ammunition of 7.62 mm and 1 hand grenade without license or permit, knowing fully it is restricted and prohibited dealings in contravention of the Firearms Act. Therefore, this honorable court will adopt 3 issues as formulated for the court determination by the defense counsel, which is similar to that of the prosecuting counsel in their final written address, which goes thus: 1, whether the prosecution has proved its case beyond reasonable doubt as provided by the law. 2, whether from the evidence of the defendant any form of defense has been disclosed. And 3, whether the defendant, a serving police officer, can be prosecuted and convicted for offense of unlawful possession of firearms without a license. To determine whether the charge has been proved against the defendant beyond reasonable doubt in view of the evidence called by the prosecution, calls for the review of the prosecution's witnesses' testimony. The PW1, Lieutenant Umar Buba Shehu, a 42-year-old administrative officer with the Nigerian Army, Headquarters Sector 2 Provost Group, testified in court regarding the arrest of the defendant at a military checkpoint, that on the 25th July 2021, soldiers from the 154 Battalion, while conducting a stop and search operation in Gamdu, detained the defendant after discovering 226 rounds of 7.62 mm ammunition and a 36 hand grenade in his handbag. The unit immediately reported the situation to their section commander in Damaturu, who instructed them to hand the defendant over to military police, where the witness serves. During the preliminary investigation, PW1 learned that the defendant was a serving police officer from the 19 Mobile Police Force in Port Harcourt, though temporarily assigned to special operations in Dikwa, Borno State, and that the defendant did not have authorization to travel at the time of his arrest. Additionally, the grenade was discovered with a partially open pin, which posed a safety hazard, prompting the battalion to detonate it in a secure area. The defendant stated that he had obtained the ammunition and grenade from his unit and intended to sell them in Edo State. After the preliminary investigation, Lieutenant Shehu handed the defendant and the confiscated ammunition over to the police CID for further investigation and possible prosecution, as their unit's jurisdiction over the case was limited due to the defendant's police status. When questioned by the prosecuting counsel, the witness explained that a detonated 36 hand grenade, being both anti-tank and anti-personnel, leaves no remaining particles due to the nature of the explosion, which will leave significant damage in its wake. During cross-examination, the witness, Shehu, clarified that while the grenade found with the defendant had a partially inserted pin, it will only detonate if the pin were fully removed. He noted he was not present during its detonation, as it was handled by the 154 Battalion, who had initially brought the grenade to him. When asked about police regulations on firearm licensing, the PW1 responded that he was unfamiliar with police protocols, as his expertise lies in military procedures. He confirmed that the defendant, a police officer whose primary assignment was in Port Harcourt, was arrested in July 25th, 2021 by the battalion while in transit through Ben Sheikh, an area under their jurisdiction. The witness further testified that his knowledge of the events at the checkpoint was based on information provided by the soldiers who made the arrest. He was not present at the scene. After the 154 Battalion transferred the defendant to sector headquarters, PW1's unit was directed to conduct preliminary investigations. However, since the defendant was a police officer rather than a military serviceman, the military police involvement was limited to an initial inquiry. Consequently, on that 1st July 2021, he handed the defendant over to the police for further investigation and possible prosecution. The PW2 DSP Ma'aji Abdul is a 32-year-old police officer attached to CID Damaturu, who is the officer in charge of homicide section, whose schedule of duties is investigation of criminal matters. He identified the defendant by name and testified that on the 31st July 2021, the defendant was transferred to the department by Headquarters Sector 2, that the defendant was arrested on the 25th July 2021 along Maiduguri Damaturu at Gamdu Village, Damaturu Road at Gamdu Village, in possession of 226 rounds of live 7.2 millimeter ammunition and one hand grenade. The suspect was transferred with the 226 rounds of live ammunition, while the hand grenade was, according to the military, detonated for safety proceedings. The defendant opted to write his statement in the presence of colleagues and the PWT's team members. After the word of caution was read over to him, he confessed to be in possession of the said ammunition, while his confessional statement was attested and brought to the witness, who endorsed the attestation. During cross-examination, the defendant, who has served 8 years in the police force, stated that as a police officer, he does not require a license to carry arms. PW2 confirmed that the defendant was indeed a serving police sergeant at the time of his arrest, that he was previously assigned to mobile police duties, and at the time of arrest was off duty on an unauthorized pass, traveling from his primary assignment in either Baga or Dikwa, where he was part of a joint military task force combating insurgency. PW2 testified that once the preliminary investigation was concluded, the case file was sent to the Ministry of Justice for legal advice, although he could not recall the specifics of the advice provided. He explained that the OC legal CID initially drafted the charges against the defendant and prepared trial documents, but due to illness, the case was transferred to the State Ministry of Justice, where it was taken over by the Director of Public Prosecution. The defendant, when questioned about the defendant's statement, PW2 confirmed that the defendant had written it voluntarily in the presence of fellow police officers, but without representation from a lawyer or family members. PW2 indicated there were indicated that he believed the defendant had only written one statement. However, if there were additional statements, PW2 could not recall them, suggesting that he's not aware of any further documentation made by the defendant. The DW1, Ebenezer Oje, the defendant, is a 37-year-old sergeant in the Nigerian police force, who testified that he was enlisted on November 1, 2008, and served in Edo State before being transferred to Mopol 19 Squadron in Port Harcourt. On January 8, 2021, he was deployed to Borno State with a unit tasked to combat insurgency. That after months in the field, he requested a leave on the 25th July 2021 to visit his family, having gotten a newborn baby in Edo State. Due to the lack of armory in the bush, he buried his weapon for safekeeping before traveling. He explained that he has also packed ammunition with plans to hand it over to colleagues in Yobe State where security risks were lower. While en route, DW1 missed his bus after stopping to relieve himself, prompting him to approach nearby military personnel for assistance in locating the vehicle. The military contacted his wife, listed as his next of kin, who confirmed his identity as a police officer. Eventually, DW1 was ordered back to the checkpoint by the military and was detained after they found the ammunition in his bag. He claimed he was handcuffed, interrogated, and subjected to physical abuse. During the interrogation, he was pressured to admit on video that he intended to deliver the ammunition to criminals, a claim he denied. The witness recounted that he was held in detention facility near the government house for a week without contact with his family. And on the day, he was asked to write a statement but was denied legal representation. That when his initial statement did not align with the coerced video, he was subjected to further threats and physical intimidation. Eventually, under duress, he rewrote his statement to match the military's narrative, believing that he'll be handed over to the police for a fair investigation. After 7 days, he was transferred to the police CID where he was again pressured to write a statement. The investigating officer assured him his case will be minor and that he would be released. Under this promise, he complied. He spent 3 weeks. Under this promise, he complied, but his subsequent attempts to engage with legal counsel were dismissed. He spent 3 weeks in detention before a brief hearing with a senior officer who indicated disbelief in his story, that he was told his time in detention will extend if he did not comply with the revised narrative dictated by the investigative officer. That after 4 months in detention, the witness was informed of his dismissal from the police force and that he would face court charges. His pleas to contact his former commands in Edo and River State were denied, and he was handcuffed and brought before the court. He expressed hope that the court would give him a fair hearing, feeling that neither the military nor the police had allowed him to fully explain his side of the story. The sections of the law the defendant is charged with and the penalties thereof are section 28(1)(a) sub 1, 28(1)(b) sub 3, 28(b)(3), 28(c) to (v), respectively, which is hereby reproduced for ease of reference. But I'll skip it, I'll not read it. As defined by law, a crime includes both the act or actus reus and the mens rea, the intent to commit the act, as can be seen reflected in this case. Criminal intent involves an intellectual apprehension of factual elements of the act or acts commanded or enjoined by the law. It is usually inferred from the apparently voluntary commission of an overt act. Criminal intent is a prior intention to commit a criminal act with the knowledge that the act is a crime. Now, being a criminal trial, the onus is on the prosecution to establish the guilt of the defendant by proving all the ingredients of the offense charge. That there is possession, illegal dealing, sale, or transfer of firearms and ammunition without license for the prosecution to secure conviction on a charge of illegal dealings in arms and ammunition. Now, this honorable court, in determining the 3 issues formulated by both the prosecution and defense counsel in their final written address, is the 3 issues for determination is 1, whether the prosecution has proved its case beyond reasonable doubt as provided by the law. 2, whether from the evidence of the defendant any form of defense has been disclosed. And 3, whether from the evidence of the defendant a serving police officer can be prosecuted and convicted for offense of unlawful possession of firearms without a license. This honorable court, having already reproduced all the 4 counts in the charge, filed against the defendant, which is in a summary form I think I've read out earlier. So the main essential ingredient of the offense prohibits the possession or control of firearms. being in possession is the key. The firearm must be in the constructive possession of the defendant. The question is, was the ammunition of AK-47 firearm of 226 rounds of live ammunition of 7.62 mm and one hand grenade firearm found in the possession of the defendant? The answer to this question can be answered in the positive, as can be seen from the corroboratory testimonies of all the three prosecution witnesses, as well as the testimony of the defendant himself, who never denied that the ammunition was recovered from him. The PW1 testified in court regarding the arrest of the defendant at a military checkpoint, that on the 25th July 2021, soldiers from the 154 Battalion, while conducting a stop and search operation in Gamdu, detained the defendant after discovering 226 rounds of 7.62 millimeter ammunition in Gamdu, detained the defendant after discovering 226 rounds of 7.62 mm ammunition and a 136 hand grenade in his bag. The unit immediately reported the situation to Sector Command in Damaturu, who instructed them to hand the defendant over to the military police where the witness serves. The PW2 testified that the suspect was transferred with the 226 rounds of live ammunition, while the hand grenade was, according to the military, detonated for safety proceedings. While the defendant himself, as the DW1, testified that due to the lack of armory in the bush, he buried his weapon for safekeeping before traveling. He testified that he had also packed ammunition with plans to hand it over to a colleague in Yobe State, where security risks were lower. Now, from the above testimonies, the first issue for determination has been resolved in the affirmative, that the defendant was found in possession of firearms, ammunition of AK-47 firearms, of 226 rounds of live ammunition of 7.62 mm and one hand grenade, and that the firearms are within the meaning of the arms as stipulated by the provisions of the Firearms Act, laws of the Federation of Nigeria, 2004. The first issue of possession having been determined, we go on to the second issue, being whether from the evidence of the defendant any form of defense has been disclosed. The defendant, as DW1, testified as follows. That he is a 37-year-old sergeant in the Nigerian Police Force, testified that he was enlisted on November 1st, 2008, and served in Edo State before being transferred to Mopol 19th Squadron in Port Harcourt. On January 8th, 2021, he was deployed to Borno State with a unit tasked to combat insurgency. After months in the field, he requested a leave on 25th July 2021 to visit his family, having gotten a newborn baby in Edo State. Due to the lack of armory in the bush, he buried his weapon for safekeeping before traveling. He explained that he had also packed ammunition with plans to hand it over to a colleague in Yobe State, where security risks were lower. That while en route, DW1 missed his bus after stopping to relieve himself, prompting him to approach nearby military personnel for assistance in locating the bus, and the military assisted him by putting him in another vehicle. That on his way, his wife called because he used her number as the next of kin in the manifest. At that checking point, they contacted her that he was nowhere to be found. That she was crying, and he said no cause for alarm, that she should forward the number to know where they are. And when he called, the driver was speaking Hausa, which he did not understand. And pleaded to hand over to military men to understand what he was saying. And the military men collected the phone and asked him questions, upon which he informed them that he's a mobile police officer from Upper 19 River State, Port Harcourt, and the military ordered him to return back to that same checking point, which he told the driver to drop him, to go back to that checking point, that he was stranded before he saw Nigerian police hillocks headed to Borno State, and pleaded and explained to the boss in the vehicle and why the military were demanding for his presence. He explained, I was having ammunition in my bag. I explained that I was having ammunition in my bag to drop with a colleague before proceeding to Edo State. They chose to drop me at that point, that the military would put an allegation on him. And he told the police boss that it is his bag as the vehicle arrested, and he needed to go back there because of the clear conscience. He went back to the point. Immediately, he said he was the owner, it was mine. The other passengers were discharged to proceed with their journey while the defendant was arrested. That when eventually the defendant was handed over to the police, that the investigating police officer took him to an office to record his statement, and which he was returned back to the cell. That after 2 months, his wife engaged a counsel for him who came to CID and was told that this is a criminal case and not a civil matter, and that the lawyer should go. That after 4 months in the cell, he was surprised that on 21st November 2021, he was taken out from the cell, that he was dismissed from the Nigerian police force and to be charged to court. That he was crying and begging them to send a signal to his command, to Edo State and River State Police Command, where he served before, and was told that a long story as decision has already been taken by the Commissioner of Police, the Yobe State Command, and that was that. And that was how he was brought to court, and he believes the court will listen and help him, since the military and the police did not listen. During cross-examination, DW1 affirmed that he was granted casual leave to leave his duty post and did not abscond. and that as a police officer, he has no need for a license to move throughout Nigeria from one command to another, that the list of ammunition he was arrested with is before the court. The type is AK-47 ammunition, and that they do not count on operational ground, that the hand grenade that was with him belongs to the military. That was why they did not bring it alongside the defendant to the police, knowing they are lying. That besides the ammunition of AK-47 of 226 rounds of live ammunition of 7.62 mm and one hand grenade, he was not caught with any hand grenade. When asked whether he knows Borno and Yobe states has different commands, he responded, it is one Nigeria police. He affirmed that different commands independent of each other, and he chose to carry the live ammunition and one grenade into Yobe State. He answered because as a mobile officer, he has immunity taken to safekeeping. And when further asked that in the whole of Borno, nowhere to surrender your ammunition, he responded that I do not know anyone there. And when further cross-examined that he was subjected to orderly room trial on 1st August 2021, for 1, discreditable conduct, 2, being absent from duty, and 3, corrupt practices, and subsequently dismissed from Nigerian police force, the defendant responded not true. The days, not true. I was taken to orderly room after 3 months in the cell, and the dismissal signal came out on the 1st November 2021. He confirmed that he's no longer a serving member of the Nigerian police force, having been dismissed from the Nigerian police force. The defendant further affirmed that he recorded his statement by himself and answered that they were working The defendant further affirmed that he recorded his statement by himself and answered that they were allowed to wear dreadlocks on their heads as serving police officers working with the Nigerian police force. During the examination, the witness was asked that at the time of the arrest, under which command was he serving? He responded, River State Command, Mopol 19 PMS, and that in the case of orderly room trial, he was supposed to be tried at his command. This honorable court, in analyzing and evaluating the defense of the defendant holistically, observed that there's a police officer buried his assigned gun in the ground and took rounds of ammunition of AK-47 firearm, of 226 rounds of live ammunition, and one hand grenade on his sojourn to see his family living in another part of the country. The defendant did not deem it fit to hand over his assigned goods, his assigned gun and ammunition to the relevant authorities in Borno State, where he was serving, for safekeeping until he returns from his approved leave. Instead, he buried the gun and left with the ammunition, claiming that he wanted to leave the ammunition in his friend's custody in Yobe State. If that is true, why did he come with the gun and hand over if that is true, why did he not come with the gun and hand over for safekeeping? Why bury the gun? And again, the defendant disembarked from the vehicle he was traveling with at the military checkpoint, and it was only when his wife called him that the driver, who has his bag with the ammunition of AK-47 firearm and of 226 rounds of live ammunition, and one hand grenade has been found, and that he made himself available. The defendant was assisted by a fellow police in a hillock who left him to his devices when he realized the extent of the problem. The defendant dwelt so much on the travails he encountered, both from the military and the police, but did not disclose what motivated him to carry ammunition and then bury the gun. Why take the ammunition for safekeeping and leave the gun in the soil? Also, taking account of the extrajudicial statement of the defendant recorded by him, which corroborated his testimony in court with the added information on how he bought the ammunition of AK-47, firearm of 226 rounds of live ammunition from some unidentified soldiers, that he intends to sell. He gave the sum he bought and how much he intends to sell. Then from the above, analysis of the evidence of the defendant, his true intention manifested itself. And from the evidence of the defendant, there's no any form of defense against the alleged charges disclosed as so hold. On the third issue for determination whether the defendant, a serving police officer, can be prosecuted and convicted for offense of unlawful possession of firearms without license, the defense counsel considered that the defendant was found in possession of firearms in his handbag, meaning within the meaning of the act. That the question is, did the defendant needed a license to carry firearms? To which counsel argued in the negative, submitting that it is right that under the Firearms Act, there's no provision to the effect that a law enforcement agent must have a license either from the President of the Federal Republic of Nigeria or the Inspector General of Police to carry or have in his or her possession any firearms as identified under the Act. Therefore, the defendant, a serving police officer, did not need a license to have in his possession the said exhibits that were found in his handbag. As such, the defendant cannot be charged and convicted under the sections he's standing trial. The Firearms Control Act number 32 of 1959 relates to private citizens and not law enforcement agents of the state. As such, the third ingredient is not established by the prosecution, even as the offense is strict liability offense. Counsel cited the dictum of Mukhtar JSC. Counsel contended by asserting being in possession of these ammunition and grenade by the defendant, a sergeant police sergeant of the Nigerian police, who did not need a license to have in his possession these arms, did not constitute a criminal offense under the Firearms Act 2004. Policemen, as officers of the law, are licensed to carry arms and ammunition. The possession of firearm by a police officer is regulated by Section 38 of the Police Act. Now, at any point in time, where a police officer is assigned to a specific duty, is given firearms, and then the ammunition must be contained in a magazine along with the firearms, AK-47 or whatever it is. The two must go together. A police officer cannot, can you close that door? A police officer cannot have firearms in a polythene or any container and then claim that he is in lawful possession. It must come from the firearms and the ammunition. It must come with the magazine and the firearms. And together, a police officer cannot have firearms in a polythene or any container and then claim that he's in their lawful possession. It must come together, like I stated, the firearms and the ammunition go together. Then the police officer must show evidence of assignment to a specific duty and where he's going for that assignment. It is just not at large. He cannot just possess the firearm at any point in time. At large, he must carry arms and ammunition for a specific duty, and he must be assigned for that duty. And he cannot, and he must provide evidence of that to the court, which has not been done. This court have taken judicial notice of the fact that the exhibit CID was not in a magazine as provided for in the Police Act, and neither was the firearm, the gun, exhibited because the defendant has buried it in the bush somewhere. Therefore, I strongly hold that there has been credible nexus between the defendant and the exhibits in his concrete possession, and control and further cemented his suspicious behavior with certainty of involvement of procuring live ammunition for sale. In the words of Oputa JSC in Bakari versus State, 1987, 3 SC, proof beyond reasonable doubt stems out of the compelling presumption of innocence inherent in our adversary system of criminal justice. To displace this presumption, the evidence of the prosecution must prove beyond reasonable doubt, not beyond the shadow of any doubt, that the person accused is guilty of the offense charged. Absolute certainty is impossible in any human adventure, including the administration of criminal justice acts or criminal justice system. Proof beyond reasonable doubt means just what it says. It does not admit of plausible and fanciful possibilities, but it does admit of a high degree of cogency, consistency, with an equally high degree of probability. As Denny J. as it then was observed in Miller versus Minister of Pensions, 1947 to All English Law Report, 373, the law will fail to protect the community if it admitted fanciful possibilities to deflect the course of justice. If the evidence is so strong as to leave only a remote possibility in his favor, which can be dismissed with the sentence of course, it is possible, but not in the least probable, the case is proved beyond reasonable doubt. Proof beyond reasonable doubt means proof of a offense with the certainty required in a criminal trial. That certainty is that the offense was committed, which is established by proving the essential ingredients of the offense, and that it is in the the person charged therewith that committed the offense. More often than not, in criminal trials, the piece of the inquiry is not whether the offense was committed, but whether it was the defendant that committed the offense. Say, indeed, versus State 2007. Therefore, the essential element of possession is conclusively established, I so hold. Thereby, all essential ingredients of the offenses has been proved as envisaged by Section 28 of the Firearms Act, Cap F 28, Laws of the Federation of Nigeria, I so hold. And on the basis of above evidence and reasoning, what this Honorable Court concluded is that the offense complained of has been proof against the defendant beyond reasonable doubt, as the burden is on the defendant to rebut the assertion of the prosecution. The question of whether the offense complained of has been proof against the defendant beyond reasonable doubt as provided for by the law has been answered in the positive. And consequent upon my finding above, I therefore hold that the prosecution has proved its case against the defendant, having established beyond reasonable doubt that all the counts in the charge has been proved beyond reasonable doubt to secure conviction of the defendant. The ingredients of processing under your control, transferring ammunition of AK-47 firearm of 226 rounds of live ammunition of 7.62 mm and one hand grenade, knowing fully it is prohibited firearm and in contravention of the Firearm Act, has been proved by the prosecution and the defendant guilty of the offense as charged. From the above analysis through circumstantial evidence, it is obvious that the prosecution has disclosed a prima facie case against the defendant, which has not been contradicted and has therefore succeeded in discharging the honors of proof placed on it beyond reasonable doubt. The defendant, Ebenezer Oje, is hereby convicted as charged. Allocators of the defendant before of the convict before I pronounce on his sentence. Any record of previous conviction? You need to speak up. Unmute your device and we're waiting for you.
My Lord, there's no record proceeding.
Charles, okay. The Mr. Oji, what do you have to say? Do you have anything to say to the court?
I want to plead before the Honorable Court.
Yes.
Yes. Now that I have been found for the Honorable Court, and I have been seeing how competent and how pitiful that you have been giving your judgment. So I am pleading for leniency because I have children and so many responsibilities. And the Nigeria police I have been dismissed from the court. You should pleading before the court to temper justice. And the court should also please look into my detention since in the 2nd of November 2021 to date. I plead before the Honorable Court.
That's it, Mr. Oti.
Thank you, my lord.
A defense counsel, any?
Yes, my lord. My lord, you have made a sound judgment, and we are not going anywhere. My lord. We are before you pleading for leniency on behalf of the defendant. My lord,
Yes.
my lord, the defendant happened to be a serving police officer at the time of committing the offense. He happens to be a first offender. With defendants, my lord, to look after and a young wife with children, my lord, who has missed him for almost 4 years now. My lord, the defendant also he has aging parents who are dependent on him before his arraignment, before this honorable court. And where, my lord,
Yes.
where, my lord, these charges call for option or fine, we will urge this honorable court, seeing that from the above, these factors we have cited above, my lord, are mitigating factors. We will urge this honorable court to give him an option.
Yes.
And to give me an option of fine with a view to temporary basis with mercy.
Thank you, counsel.
As it is as noted by the defendant, my lord, it is the public acceptation of this honorable court that my lord always stands for justice and fairness. So it is with that we urge my lord to keep on in that trend in the interest of justice. Thank you, my lord.
Sentence.
Please, my lord.
Having listened to the plea mitigation made by the convict, and this court having taken all that into account in passing sentence on the convict, I take into consideration that he's a first-time offender before this court, but the convict, being a policeman who utilized the trust reposed in him to abdicate his responsibility as a Nigerian policeman, to turn dark and undermine the system, thereby jeopardizing the security of Borno and Yobe citizens, and by implication, the citizens of this country. The office of a police officer is that of trust. Whenever there's any problem or difficulty, citizens rush to the police for help and assistance, as policemen are public servants. Now, for such a policeman to abdicate this trust is alarming. For him to willingly buy ammunition held in trust for the well-being of Nigerian citizens is undermining the system. That is really sad and leaves so much to be desired from an officer of the Nigerian police force. Consequent upon my findings above, the defendant having been found guilty to all the charges, the counts in the charge, I have found the convict, Ebenezer Oji, guilty of the offenses as charged, as earlier stated, in count 1, and sentenced to 8 years imprisonment, that's 10 years being the minimum. But I'm reducing it to 8 years. For both count 2 and 3, the convict, Ebenezer Oje, is sentenced to 8 years imprisonment each. For count 4, the convict is sentenced to 2 years imprisonment. The sentence shall be deemed to have commenced from the date he was arraigned before this court. When he was apprehended and arraigned before this court. Pursuant to Section 28 of the Firearms Act, laws of the Federation of Nigeria. This is to serve as a punishment to you and a deterrent to others. This honorable court admonishes you to stay away from crime or any of its appearances. Essentially, the essence of punishment is to obtain a reformation in the subjects you are enjoined to stay true to your words and lead an exemplary life or to serve in a sentence. The sentence is to run concurrently, not consecutively. This shall be the first sentence of the convicts, which sentence is no doubt very light. It was deliberately made so in order to encourage the convict to quickly retrace his steps and return to the society as a changed person. Meanwhile, this honorable court orders as follows: the seized exhibits recovered from the convict hereby confiscated and shall be forfeited to the federal government of Nigeria through the Inspector General of Police, portion to Section 28(3) of the Firearms Act, laws of the Federation of Nigeria, which provides that any court of law may order the forfeiture of any firearm or ammunition to which the offense relates, and any such forfeited firearm shall be disposed of in accordance with the instructions of the Inspector General of Police. This is my decision. The convict has 90 days within which to appeal both the conviction and sentence if he's not satisfied with same. Thank you. Please call the next case.
Part number FS/DM/CR/23/2021 between Bureau from Nigeria and Mr. Bukar and Ibrahim Haruna.
Yes.
Yes.
Correct.
With profound respect, my lord. F.I. McKintemi, DDL, from the Aegis Chamber, appearing for the complainant, my lord.
Correctional Center, please unmute your gadgets.
Wait, please, my lord. R. Muhammad is my name, appearing for the complainant, my lord.
Yes, my lord, the matter is adjourned to today for judgment, and we are ready, my lord, subject to the court convenient, my lord.
We are equally ready, my lord.
Correctional Center, are you still there? Okay, they are yet to unmute their. Can you unmute your? Can you hear us? Because anyway, okay, if you can. I think I need to apologize to council that the ruling is not ready, and a date next week. I will adjourn it to a date next week. Give me a date registry for a virtual date.
A virtual.
Just give me a minute. Today's 15th?
Yes.
19th. Council, 19th, okay?
As court pleases, since it's virtual, it's okay, my lord.
Okay, I'm sorry. I've had so many other judgments. It's please, Mr. Salisu, apologize to the inmates. The matter is adjourned to 15th day of November, 19th day. That will be on Tuesday for the judgment to be delivered.
His court, please.
Thank you. Please call the.
Chart number FS/DM/3/2024 between Kero Nigeria and Adamu Zakaria.
Respectfully, my lords, my name is Usman Bamala. My appearance is for the complainant. My lord, the matter is fixed today for sentencing and subject to my lord's convenience, we are ready to proceed.
Talisu, your gadget is muted. Let me have file A, please. Can you unmute your device? We cannot hear you.
My lord,
Okay. Yes. This matter for sentencing today. At the last adjourned date.
Yes, my lord. At the last adjourned date, we reviewed the facts of the case, and the court has convicted the defendant as charged. I haven't reviewed the fact of the case, and my lord, in its wisdom, have considered the fact of the case, my lord, to summon the elders of the convicts, my lord, considering the special circumstances of the case.
Are the elders in court?
Yes, my lord.
Well, they have not seen them. Do you understand English or only Hausa language?
my lord, Hausa.
Yes, ask them. I asked a question. Can you tell, do they know why they are in court today? What is the reason? What is their names first? Abdullahi. Yes. Muhammad Hassan. Yes. Are you related to him? How about the other person, Muhammad? You are his uncle. the convicts was brought to this court. Can you interpret? He was found in possession of some amounts of narcotics. Realizing that he looks like a decent person with a family, with 7 children, he said, and a young person, I didn't want to just send him to prison because of the negligible amount found in his possession when arrested during a raid. Well, I think what I didn't say, don't say. I didn't say all that. Anyway, continue. But you are going to stand in as his guarantors. It's going to be, anyway, I'll have to read that for them to, I'll read the sentence and for you to interpret to them. Sentence.
Escort, please, my lord.
The convict, Adamu Zakaria, who was arraigned before this court on a 2-count charge of being in possession and dealing in cannabis sativa, a narcotic substance, which are offenses under Section 19 and 11B of the NDLEA Act, Cap 30, laws of the Federation of Nigeria. The convict pleaded guilty to the counts, and the legal counsel to the prosecution applied for a summary trial, which this court obliged in line with Section 27412 and Sections 375 of the Administration of Criminal Justice Act. In passing sentence on the convict, the fact that the convicts have pleaded guilty to the charge on first arraignment, and of the fact that he appears remorseful are factors which ought to inform the sentence which this court will pass. I also take into consideration the plea mitigation made by the convict for himself and the plea made by the prosecuting counsel for the court to temper justice with mercy, as the convict was remorseful from the point of arrest and a novice. But the court is also required, especially in cases involving dealing in narcotics and controlled psychotropic substances, to take into consideration the nature of the drugs or psychotropic substance involved. Considering the amount found with the convict and the adverse effects it's having on him, being a family man with children, imagine how many people's life would be jeopardized if it was not intercepted by the NDLEA enforcement agents. Therefore, there's a need to give a deterrent sentence to send the message that such acts are not acceptable. This honorable court, during trial, had the advantage of personal observation and is of the strong view that the case merits a reduction in sentence in view of the plea of guilt at first arraignment, that the convict is a young man with a promising future The convict is a first-time offender, and as a result of the not so considerable amount of the nefarious substance found in his possession, which has not been proved scientifically to the satisfaction of the court, as the substance was only field tested, not scientifically proven by an analyst in the scientific laboratory. I also take consideration the plea in mitigation made by the prosecuting counsel for this court to temper justice with mercy. Being a young man assisting parents with and helping his own family. In the final I have to consider the position of the convict at the time he committed this offense. He's a young man with no definite job, assisting his family. It is to be noted that the offense for which the convict was arrested relates to possessing cannabis sativa, and such offenses relating to drugs are very serious offenses, particularly in this era of insecurity we are in this country. If the convict is one of such devious businessmen, he should desist forthwith. And please let them sit, sorry. Let them sit. He should desist forthwith. As a young man with a promising future, he should engage himself in legal business that will contribute to the development of the society, not to engage in such disgraceful activities that will destroy the society he lives and gets his sustenance from. This honorable court encourages the convict to turn over to a new leaf and be reformed, and will impose a sentence that will serve the purpose of rehabilitation and to correct the personality or behavior of the offender through therapeutic treatment, with the major goal of returning him to society as a law-abiding citizen by being of good behavior. The idea is the bad habit or the bad behavior of the offender needs to be broken and new habits cultivated. In the final analysis, the convict will receive punishment in public view in order to deter other individuals from such deviance in the future. I hereby sentence you, Adamu Zakariyau, the convict, to perform community service. You'll be engaged in graveyard cleaning by clearing the shops, trees, and any collapsed grave in the assigned graveyard that either in Potiskum or in Damaturu here. The discretion of which graveyard will be that of the chairman, Graveyard Association Damaturu, who will still act as a guarantor and will monitor the convicts. The convict is to follow all instructions by the chairman of the Graveyard Association of Damaturu, and to mentor him by engaging him to work at the graveyards so that he can be of benefit to himself and to the community. I asked the relatives of the convicts to come so that they too are going to be guarantors. If for any reason they are to liaise with the chairman of the Graveyard Association to ensure that the convict goes to the graveyard as is ordered by this court. The convict is to be counseled and monitored for 1 year. The implementation of the orders handed down by the court must be documented with detailed information. The registrar of court is co-opted as well. All information about the name of the convict, sentence and date of the sentence, name, duration of the remand, residential address of the convict, photographs, and other means of identification as may be appropriate. All the information about the convict to ensure that it's been monitored and do not go back to the same dastardly and reprehensible acts of smoking and selling illicit substances. The brothers or the parents, like I said earlier, are the guarantors and to ensure the convicts adhere to the schedule that is to be drawn up for putting the convict to work. This is to serve as a punishment to you and a deterrent to others. This honorable court admonishes you to stay away from crime or any of its appearances. Essentially, the essence of punishment is to obtain a reformation in the subject. You are enjoined to stay true to your words and lead an exemplary life after serving your sentence. The exhibit found in the possession of the convict without lawful authority shall be returned to the office of the NDLEA and shall, as condemned substances, be confiscated and forfeited to the federal government of Nigeria. If for any reason the convict refuses or did not adhere to the plan stipulated or laid down for him, he shall then be remanded in prison for the remainder of the period for the 1 year that he has not served. The convict has 90 days within which to appeal both the conviction and sentence if he's not satisfied with same.
Yau ne kotu ta kammala duka hukunci akan wannan shari'a wanda ta ba da cewa shekara ɗaya ne aka baka na wannan laifi da ka aikata din kamar haka kamar yadda ta faɗa. Sannan kuma bayan ka yi shekarar da aka koma cikin al'umma ka zama mutum na ƙwarai kuma ka risanta kanka da aikata wasu
Salisu.
Yes, my lord.
I did not say to stay 1 year where? You didn't hear the...
As court please, my lord. Kotu ta baka, ta hukunta ka da aikin makabarta shara da makabarta za ka na yi na kimanin shekara ɗaya. Kuma ta sa hukumar makabartar kotu ta ba su umarnin suna kula kana gudanarwa da aikin da aka saka na shekarar in kana yi shikenan ka shekara ɗaya in kuma ba ka yi kotu za ta zo a hukunta ka ɗaure kake yan kamar yadda kotu ta sai. Makabartar kuma da ke dama ko abu nan fata su.
Did he miss anything, prosecuting counsel? Okay. Thank you. Call the next case. Yes, they are not supposed to call it if it's for physical. Remove it. Let's finish with the correctional center quickly. Talk to Salisu, he didn't hear you.
My lord, we didn't hear.
Salisu,
Yes, my lord.
The case that has just been called is CR 49 2023, Alhaji Gira Bulama.
Alhaji Gira Bulama. My lord, the defendant is here at the correction center, my lord. And
respectfully, my lord, my name is Uthman Bamala. My appearance is for the complainant. My lord, the matter is fixed today for review of facts subject to my lord convenience. You are ready?
Lauya mai gabatar da ƙara yau ne ranar da aka gabatar da ainihin abin da kayayyakin da aka samu a wajenka, da haka yana shirye da a gudanar.
My lord, we intend to review the fact of this case through the exhibit officer in person of Mr. Bagudu David, Mr. Suleiman, sorry, my lord, Suleiman Muhammad Rabiu, who is the exhibit officer in this matter.
My lord, who is present. He is ready, my lord, to affirm. Let me affirm myself. I solemnly affirm to interpret court proceedings from English to Hausa and vice versa to the best of my ability. Sorry. Can you affirm yourself or affirm? My lord, he is ready to affirm yourself.
Let's go ahead.
I, Suleiman Mohammed Rabiu, do solemnly affirm that the evidence I shall give before this honorable court shall be the truth, nothing but the truth. So help me God.
My lord, the PW1 is affirming is male, adult, and Muslim.
Yes.
Please once again tell this honorable court your names and what do you do for a living.
My name is Suleiman Mohammed Rabiu Suleiman. I'm a public servant working with the National Drug Law Enforcement Agency, Yobe State Command.
You may have a seat if there's a seat there.
Okay, my lord.
Tell this court for how long have you been working with the agency and what rank do you emanate so far?
I'm an assistant superintendent of narcotics too, and I've been working with the agency for almost 4 years.
Please kindly look at the defendant in this matter and tell my lord whether you know him.
Yes, I know him in respect of this case.
Good. Tell my lord, what are your schedule of duties for all these years you have spent in the course of your duties, and what do you know about the defendant in this matter?
Mr. Rabiu.
Yes, my
before
lord.
you continue, let Mr. Salisu interpret so far the proceedings.
Yau lauya mai gabatar da ƙara yana tambayar ba da sai na yace a ina yake aiki, yace yana aiki da hukumar hana sha da safarar miyagun ƙwayoyi ta ƙasa. Sai yace ya kai kuma wani shekaru kamar yaushe ya fara aiki, yace ya kai wasu shekaru kamar yadda ya faɗa yana gudanar da aiki. Shine yanzu ko ta ce ana fassara ma kamar yadda ko ta ba da dama. Yace shi ma'aikaci ne na hukuma kamar yadda ya faɗa.
Yes.
Receiving the suspect and the exhibit recovered from them, carrying out a field test on the recovered exhibit and weighing of the exhibit, taking some part of the exhibit and seal it in a white evidence transparent pouch A1 for scientific analysis.
Sannan aikin nasa ya ce suna gudanar da bincike akan abin da kayayyakin da aka samu a wajen mutane, kuma sannan suna ɗaukan sample su bayar a ƙwararru a ƙara gudanar da bincike a tabbatar wannan abun shi ɗin ne da ake nema kamar hanyar da yake faɗa.
Issue of exhibit forms, namely certificate of test analysis, packaging of substance forms, request for scientific aid forms for the suspect and the witnessing and arresting officer to sign, keeping at.
Ganaji ya ce sannan kuma su ne suke ba da wasu forms da yake tabbatar da shaida da shi wanda ya yi laifi da su masu gudanar da bincike duka a yi gudanar da cika wannan form din a kuma sa hannu wani waje ma har a yi template a dangwala yatsa.
Keeping the bulk of the exhibit A3 in an exhibit room for safekeeping, taking A1 to Lagos for scientific analysis, testifying and giving evidences in court with regard to the exhibit handled by me or kept under my custody, and any other adverse duty given to me by my commanding officer.
Yace kuma sannan wannan kayayyakin sukan ɗauka shi ɗin ne yake ɗauka yake shi ne ma'ajiyinsa a ƙarƙashinsa, sannan kuma yakan ɗebi wani a tura Lagos don a ƙara gudanar da bincike a kai. Sannan kuma yanzu yana zuwa ya bada shaida a kotu kamar yadda za ka yi bayyana gaban kotu ke bada shaida, shi ne aikin sa.
On the 8th of October 2023, my lord, the defendant was brought before me by one Usman M. Sapio and Hashimu Aminu.
Ce a wata rana a watan 10 shekarar da ta gabata, kamar yadda yake faɗa, aka kawo ka gabansu.
Usman Shafiu and
Hashimu Aminu.
Yana lokacin ya tare da wani Usman Shafiu da Hashimu.
Yes.
Along with a bako bag, black bako bag.
Ka zo da wata bakan leda, jaka baka.
Yes.
I asked the defendant who owns this black bako bag, and he said the bag belongs to him.
Tambaye ka wannan bakan jakar ta waye, kace jakar ka ce.
With his permission, I opened the bag and I discovered that there are some dried leaves suspected to be cannabis sativa.
Sannan da amincewar ka ya bude wannan jakar, ya tabbatar aka duba shi aka tabbatar da cewa akwai wani busasshen ganye da ake zargin tabar wiwi.
Yes, go ahead.
I then informed him that I want to carry out a field test on these substances, and he gave me go ahead.
Sannan ya tambaye ka za a ɗiba na abu da bincike a kai, kace ba wani abu.
After carrying out the field test, the test proved positive for cannabis sativa, and it was weighed.
Sannan bayan gudanar da binciken, a wannan binciken ne aka tabbatar da cewa wannan abin tabar wiwi ne wannan busasshen ganye.
And it was weighed and found to be 2.5 kilograms.
Nauyinsa kuma ya kai kilogram 2.1, 2.5.
Yes, go ahead.
Okay, thereafter, I brought out some exhibit forms, namely certificate of test analysis, packaging of substance form, request for scientific aid forms. I filled my own necessary columns.
Sannan a lokacin ne aka ba da wasu takardun shaida kamar haka, wanda ya faɗi sunansu, wanda yake tabbatarwa da haka.
Arresting and witnessing officer also filled their own column, and the suspect thumbprint on the forms.
Sannan da su wanda suka kwano ka da su wanda suke ba da shaidar duka da kai din ma an baka ka dangwala yatsa, su ma kuma sun cike wasu gurare kamar yadda aka ba su.
I took some part of the exhibit and sealed it in a white evidence transparent pouch A1.
Sannan akwai wani leda da ake kira A1, an ɗebi sample a ciki, ya ɗebi sample ya zuba a ciki.
And I kept the bulk of the exhibit A3 in an exhibit room for safekeeping.
Sannan sauran ainihin ishi kayan ya ajiye shi a ɗakin ajiyarsu na kayayyakin.
On the 2nd of November 2023,
ranar 2 ga watan 11 shekarar da ta gabata,
I arrived at Lagos for scientific analysis.
Ya sauka a Lagos don gudanar da bincike akan wannan abu.
And I received a response on the 7th day of November 2023.
Ranar 7 ga watan 11 kuma ya samu sakamakon wannan binciken da ya je akan kayayyaki.
Calling my attention, Sulaiman Mohammed Rabiu, OC Exhibit NDLEA Yobe State Command.
A wannan lokacin ake sanar da shi kamar haka, shi din Sulaiman Mohammed wanda yake jihar Yobe a ƙarƙashin hukumar dokar nan ta hana shan safara.
Along with a brown envelope.
Da wata takardar shaida ta envelope da ake kira.
Attached with the brown envelope is the result for scientific analysis and the request for scientific aid form.
Wannan takarda ta envelope din an haɗa ta an sa shi ainihin sakamakon wannan gwajin da aka gudanar da aka kai libasin.
Thank you, my lord.
Yace shi ne iya wannan isa ya gode. Na gode.
Mr. Muhammad Rabiu Suleiman.
Yes, my lord.
You just informed this court that you issued some exhibit forms to the defendant, which include the certificate of the test analysis, the packing of the substance form, and the request for scientific aid form, where the defendant filled the respective column you equally did, and the arresting and witnessing officer. Am I correct?
Yes, my lord.
Thank you very much. You equally informed this court that you took a sample of the exhibit for forensic analysis, and there was a response of the drug analysis report. Attached to it is a brown envelope and the request for scientific aid. Am I correct?
Yes, my lord.
Tell this honorable court, if you see this form, will you be able to identify it?
Yes, my lord.
Tell this court how you can identify it.
In both of the documents, my name is written there, date of documentation, and in the request for scientific aid form, packaging of substance form, and certificate of analysis, my signature was also there.
Thank you very much.
Yace akwai wasu takardun shaida da aka tuttuka kamar yadda ya faɗa, shine zai sai yake tambayar sa cewa wannan takardun zai iya saida su, yace zai sa saboda zai iya ganewa saboda akwai sa hannunsa a jiki da sunansa.
I need to tell the court how you can identify all the said aforelisted forms together with the bulk of exhibit.
In all of the documents, my name is written there, date of documentation, and my signature is also there.
Thank you very much. Now, where is the forensic analysis, and which you claim it is in a brown envelope, and the bulk of exhibit, where are they?
They are here with me at the correctional center, my lord.
Can you show it to the court for identification? Okay, what is this one?
It's forensic analysis report.
No, let him, he's the one that's supposed
He's the
to
one
answer.
that will say, not you.
My lord, this is the brown envelope together with the result from the scientific analysis.
Yes.
In the circumstances, my lord, we apply for the witness to open the said brown envelope to ascertain what it contains.
Application granted.
My Lord, this is the result for the scientific analysis, and this is the request for scientific aid form, and this is the remnant from the scientific analysis, together with the brown envelope.
Thank you very much. Can you equally show, my Lord, the bulk of exhibits as well?
Yes, my Lord.
Thank you. My Lord, we apply for the witness to open the brown envelope to ascertain what it contains.
The brown envelope?
Sorry, the bulk of exhibits contained in black bako bag.
Go ahead. Go ahead.
My Lord, this is the bulk of the exhibit. 5 compressed blocks of cannabis sativa wrapped in a yellow sellotape.
Thank you very much. You can take it down. I think my Lord, yes.
Yes.
And the NDLA case number written on the back of the bulk of the exhibit is written as NDLEA stroke YBSC
Yes.
stroke 046 stroke 2023.
Yes.
Thank you very much. My Mr. Muhammad Gabiu.
Yes, my Lord.
Here with me is the QM certificate of the test analysis and the packing of the substance form. Is this the certificate of the test analysis you are talking about?
Yes, my Lord, that one.
Is this the packing of the substance form you are talking about?
Lift it up small, my Lord. Yes, yes, it is one.
Thank you very much. In the circumstances, my Lord, we sought to tender the packing of the substance form, certificate of the test analysis, the request for scientific aid form, the drug analysis report, the brown envelope, together with the white exhibit form containing the remnant of the exhibit in evidence before this court. Thank you, madam.
Alice, you can sit.
Yes, ma'am. That's good, please.
What is the kilogram again?
2.5 kilograms, my lord.
The following exhibits are hereby admitted into evidence. The certificate of test analysis form, the packing of substance form, request for scientific aid form, marked as NDLEA GERA 1A, 1B, and 1C respectively. The drug analysis report, the brown envelope, the white transparent evidence pouch with the remnants of the analyzed exhibits as NDLEA GERA 2A, 2B, and 2C respectively. The bulk of the dried weed suspected to be cannabis confirmed to be cannabis sativa, comprising of 5 compressed grams with NDLEA number NDLEA-YBSC 046-2023 is hereby marked as NDLEA GERA 3.
Very much grateful, my lord. That's all for the review of fact, my lord.
Mr. Salis,
Yes, my lord.
can you show him these documents and the exhibits just tendered and ask him whether what the exhibit officer, the witness, just stated is the true position or the facts of the case?
As court please, my lord. Wuce ta ce a tambaye ka, wa'annan ko su ne takardun da aka cika din kana nan lokacin? Kuma sannan wannan din su ne abin da aka samu a wajen ka? Wannan shi ne abin da aka samu. Yes, my lord. Ka ɗaga muryar ka sosai. Wannan shi ne abin da aka samu a wajena. Yanzu kawai na neman alfarma ya rike mu da sassauci.
Ask the witness. Ask Mr. Saliu.
Yes, my lord.
Ask him if he has any question for the witness, for the exhibit officer.
Wanda ta ce a tambaye ka, ko kana da tambaya da za ka yi wa shi ofisa ɗin da ya ba da saida? Ba wani tambaya da haka ne abin ya faru da ni na wani. Yes, my lord, he has no any question.
My lord, that's all for the witness. We apply for the witness to be discharged from the witness box.
Application granted. Thank you, officer.
Thank you, my lord.
My lord, we equally apply the defendant to be convicted as charged.
Ask the defendant if he has any cause to show why he should not be convicted as charged.
Bisa ga amincewa da kai wannan sai da suka bayar a kanka da komai, sai kotu ta ce a tambaye ka ko kana da wasu dalilin da zai sa ba za a hukunta ka ba?
Wani da wani dalilin da ba za a hukunta ba, kawai ina neman albarma ne.
The defendant, who indicated that he was not literate in English language, had the two-count charge dated, read and interpreted to him through a sworn interpreter. He pleaded guilty to the count in the charge. The learned prosecutor consequently indicated his intention to conduct a review of the facts of the charge. This was an exercise which is peculiar to drugs and related offenses and was not meant to require the prosecution to prove the allegation in a criminal charge which the defendant or accused person had voluntarily pleaded guilty to by the provision of the law, except in capital offenses. Once an accused person has pleaded guilty to an indictable felony punishable with a term of imprisonment, the court is empowered, especially in relation to the Federal High Court, who by Section 33(2) of its Enabling Act, Cap F12 laws of the Federation of Nigeria, 2004, empowered to try criminal cases and matters summarily, to proceed to convict the defendant. The exercise to do a review of the facts of the charge was consequently done. I've listened to the learned prosecutor, Usman Bamala Esquire, who has produced certain documentary and real exhibits which have been admitted in evidence. The exhibit seized and recovered from the defendant is cannabis sativa, a narcotic substance. It's one of the hard drugs which the extant legislation, the NDLA Enforcement Agency Act, has outrightly, except where lawful authority is shown, prohibited its sale, possession, and consumption. The defendant, who on arraignment pleaded guilty to the charge, has not produced any evidence of lawful possession of the exhibits. I'm satisfied against his plea of guilty and scientific proof of the exhibits that the case against the defendant has been proved beyond reasonable doubt, as is required by sections 137 and 138 of the Evidence Act 2011. In view of the plea of guilty entered by the defendant and in line with the provisions of sections 2741 and 2 and 3561 and 2 of the Administration of Criminal Justice Act 2015, this court hereby find the defendant alleged Gira Bulama guilty of knowingly, without lawful authority, possessing 2.5 kilograms of cannabis sativa, a narcotic drug similar to cocaine, heroin, and LSD, and by which act you committed an offense contrary to and punishable under Section 19 and 11B of NDLA Act, laws of the Federation of Nigeria. The convict, the defendant, sentence. I've just convicted the convict.
As God please, my lord.
Lord, the convict has no previous record of conviction. Lord, the convict has also, as judicially noticed, he did not stretch this court to undergo a rigorous trial before arriving at the conclusion of this matter. In the circumstances, my lord, I urge my lord to consider same as mitigating factor. Thank you very much.
Gabatar da ƙara ce baka da wani rekod da aka taba maka hukunci ko ka aikata irin wannan din. Shine yace baka taba aikata wani irin wannan din ba, shine na farkon laifin da ka aikata kamar da kotu ta tabbata.
Does he have anything to say to the court
Ko kana da
before
wani abu da
sentencing?
ko kana da wani abu da zaka gaya a kotu?
Kotu ni alfarma ne nake nema. Yanke mun hukunci ina da iyali kuma tun da na shiga halin na a gidanmu ma ba inda wanda ya sani.
Just a minute. Yes.
Tun daga 23 an kama ni har yanzu a gidanmu ma ba a san a ina nake ba.
Yes.
Kuma yana da yara kuma mahaifiyana ta rasu. Ni ne nake rike da mamana da kannuna duka. Ni nake rike su. Saboda haka ina neman alfarma.
Is that it?
Ina neman alfarma, ina neman sassauci kotu mai girma mai shari'a. Ina da yara, babana ya rasu, mama na ita kadai ne, kuma ina da kannu, ni nake kula da su. Saboda haka ina neman alfarma ta mai girma mai shari'a. Thank you.
Exhibit, do you smoke or do you sell?
Sha kake ko sayarwa?
Ni ban taba saidawa ba, wannan shine na fari, kuma shine na karshe, insha Allah. Na dauka alkawari.
It was arranged 18th October 2023. Okay, come forward.
And
18th or 8th?
he was arrested sometime around 8th of October 2020 last year.
18th.
And he was arraigned on the 18th of October last year, 2023.
And since then, he was
He has been
remanded.
in custody.
Sorry?
Since then, he has been in custody. Since then, yes. So, my lord, I think one of the reasons of his delay is I think the matter was later transferred, I think, to the other.
Yes, it was transferred to court 2.
To court 2, and the charges was released, and there was no progress, and before it comes back as a result of mix-up of number of cases, my lord. So that was the reason why this matter delayed up to this time. And I think in court 2 he has even opted to take a lawyer, and the matter was called up, and the matter did not proceed. We didn't proceed with the matter as a result of the counsel was not in court, and he was actually not in court. And court 2 does not accommodate physical, does not accommodate virtual trial. I can confess, my lord, if not because of this virtual trial, this matter, even today, we will not come up to the end of this matter.
10th. The convict Alhaji Girabulama was arraigned before this court on a 2-count charge of being in possession and dealing in cannabis sativa and narcotic substance, which are offenses under Section 19 and 11B, subsect C of NDLA Act, Cap 30 laws of the Federation of Nigeria. The convict pleaded guilty to the counts, and the learned counsel to the prosecution applied for a summary trial, which the court obliged in line with Section 2741 and 2 and Section 375 of the Administration Criminal Justice Act. The convict pleaded guilty to the charge, and in his plea of mitigation for himself, he said it is for the court to temper justice with mercy, being a family man. This court has taken into consideration that the convict is a first-time offender before this court, but the court is also required, especially in cases involving dealing in narcotics, to take into consideration the nature of the drugs involved. I have to consider the amount of dried weed substance, compressed dried weed substance found with the convict, and the adverse effects and colossal damage it causes in society. Imagine how many people's lives would be jeopardized if it was not intercepted by NDLEA enforcement agents. Therefore, there's the need to give a deterrent sentence to send the message that such acts are not acceptable. Quantity of the dried weed substance recovered from his possession was about 2.5 kilograms. It's a considerable amount, which betrayed him as a commercial dealer, although he said this is the first time he's into this business. But by so doing, he's endangering the society in general by such nefarious business or activities. This can be confirmed from the statements made to the NDLEA. And again, in view of the fact that possessing and dealing in illicit drugs has been adjudged as an organized economic crime, my fear is that such a convict, once he has finished his sentence, will readily go back to crime. to the same illicit business in the hope that even if he's caught, it's a question of a few months incarceration and he'll be released to return to the business and make good money in illicit dealing and trading in such drugs. Although he has pleaded that he is formed. A sentence that is comparatively too light will not serve as a deterrent to the individuals who are involved in similar criminal activities or deter those who are already contemplating getting involved or being groomed by the drug lords to be used as traffickers for a commission as fees. It is obvious when this occurs, the court has not discharged its statutory duty well in ensuring that the sentence is one which strikes the delicate balance which are briefly analyzed and which are essentially psychological in nature. This honorable court, having regard to the consideration and analysis which I've done, and also having taken judicial notice of the fact that the convict has shown remorse by willingly or voluntarily assuming responsibility for his conduct by pleading guilty with false arraignment, and of the fact that he's a first-time offender before the court. I stated earlier, I have to consider the drug with which betrayed him as a commercial dealer, though he's a young man with a bright future. If the convict is a devious businessman, he should desist forthwith. As a young man with a promising future, he should engage himself in legal business that will contribute to the development of the society, and not to engage in disgraceful activities that will destroy the society he lives and get sustenance from. This honorable court encourages the convict to turn over to a new leaf and be reformed. Consequently, having regard to the considerations which are analyzed are factors which ought to inform the sentence which this court will pass. In the final analysis, I hereby sentence you, Alhaji Gira Bulama, to 12 months to 15 months imprisonment for the first count, 15 months imprisonment for the second count, 15 months imprisonment for the third count, for the offenses you have been convicted of to commence from date of arraignment. The sentence is to run concurrently. This is to serve as a punishment to you and a deterrent to others. This honorable court admonishes you to stay away from crime or any of its appearances. Essentially, the essence of punishment is to obtain a reformation in the subject. You are enjoined to stay true to your words and lead an exemplary life after serving your sentence. The exhibits found in the possession of the convict without lawful authority shall be returned to the office of NDLEA and shall, as condemned substances, be confiscated and forfeited to the federal government of Nigeria. I shall, pursuant to the extant laws of Nigeria, be destroyed by the NDLEA by burning. At a public function, it will organize for the destruction of all judicially condemned narcotic and psychotropic substances. The event shall, on NDLEA's invitation, be witnessed by representatives of the Nigerian Police Force, the DSS, the NDLEA, the Civil Defense, and the NAFDAC, NESRIA, as well as the press board, the print and electronic media, and the general public. The convict has 90 days within which to appeal both the conviction and sentence if he is not satisfied with same.
Yau ne kotu bisa kammala dukkan jawabai da ta yi da kuma gudanar da aikinta kamar haka akan tuhuma guda biyu da ake yi, inda kotu ta tabbatar da hukunci kamar haka. Tuhuma ta farko dai kotu ta ɗaure ka wata 12, tuhuma ta biyu wata 15, sannan ta ce hukuncin yana da cike da sassauci. 3 years? Okay, tuhuma uku.
3 counts, Malam Salisu.
Yes, my lord, as God please. Tuhuma ta uku ma wata 15 kamar yadda na gaya ma. Tuhuma ta farko wata 12. Tuhuma ta biyu wata 15. Tuhuma ta biyu wata 13. Tuhuma ta uku wata 15. Kamar yadda kotu ta sanar. Ta ce kuma lalle hukuncin yana cike da sassauci saboda ita wannan harka da aka same ka da ita laifin harka ne mai bata al'umma da bata ƙasa gaba ɗaya. Ko ta yi la'akari da cewa kai shine na farko da ka fara aikatawa. Sannan kuma ka kiyaye duran da irin makamancin haka ya faru, dole za ka fuskanci hukunci mai tsauri kamar yadda kotu ta faɗa. Sannan kuma ce in ka ga hukuncin bai game ka ba, daga nan zuwa kwana 90 da ka iya, kana da 'yancin ka je ka kai kotun gaba. Shi ne abin da kotu ta faɗa.
Concurrently, Malam Salisu.
Ya fara daga ranar da aka kama kai. Kuma sannan duka guda uku din, duka hukuncin tare zai tafi, ba wai daban-daban ba ne.
Yes, call the next case.
Touching my emphasis like
Correctional cases, are we done with that?
touching on the emphasis like DM/self like 26/14 between Kero Kowanjira and Muhammad Gwani.
Muhammad Gwani. My Lord, the defendant is here at the lecture center.
Respectfully, my lord, my name is Usman Bamala. My appearance is for the complainant.
Gabatar da ƙara ne ya faɗi sunansa.
My lord, the matter is fixed.
A minute, counsel. I'm trying to bring up the file.
Let's go, please.
CR 26. Yes, counsel, go ahead.
My lord, the matter is selected today for review of fact and subject to my lord convenience. We are ready to proceed.
Correctional Center.
Yes, my lord. Yeah.
Okay.
My lord, we intend to review the fact of this case through the exhibit officer in person of Mr. Bagudu David. My lord, we apply Mr. Bagudu David to appear in the witness box.
As court please. Ya ce yau ne ranar za a gabatar da ainihin kayan da aka samu a wajenka, sannan akwai shaidar su da ya bayyana, ya ce na so kotu ta ba dama a sai da yanzu kamar haka. Ga sai da kuma ya bayyana.
Yes.
Yawa. Wannan shi zai ba da sai da kamar haka a kanka. My lord, the feeder below one is here at the correction center present. He is ready to affirm himself.
Yes, go ahead.
I, Bagudu David, do solemnly affirm to state that the evidence I give in this case before this honorable court have been the truth, the whole truth, nothing but the truth, so help me God.
My lord, the feeder below one is affirmed himself, he is male, adult, and a Christian.
Thank you. You can have a seat, officer.
Oh, thank you.
Once again, tell this honorable court your names and what do you do for a living.
My name is Bagudu David. I work with the National Drug Law Enforcement Agency, Yobe State Command.
Tell this honorable court for how long have you been working and what rank do you attend so far?
I'm a superintendent of narcotic. I've been working with NDLS about 13 years ago.
Please tell this honorable court what are your schedules of duties and what do you know about the defendant in respect of this case? Please proceed.
Receiving suspects and then being recovered from there. Carry out a field checks and weighing of the recovered exhibit. Testify in court. Isn't exhibit form for suspect to sign, arresting officer also to sign. Taking the drug sample that is A1 to NDLA lab in Lagos for forensic analysis.
Lauya mai gabatar da ƙara ya ce ya gabatar kotu ya sunan shi, ya faɗi sunan shi da aikinsa da kuma irin aikin da yake gudanarwa a ofisin nasa, kamar da yanzu ya faɗa.
Kindly, let me repeat myself. Kindly tell this court, what do you know about the defendant?
On the 29th of April 2024,
yes,
the defendant was brought before me by two of NDLA officers, namely Ape Anthony Ako and Soromi Siga, along with a Smith Bois brown bag containing 2 compressed blocks of dry weed suspected to be cannabis sativa. I carry out a field test of the recovered exhibit and weighing of the recovered exhibit in the presence of the defendant.
Let him interpret what you have stated so far.
Yes, Lord.
Ya ce wata rana yana ofis yana tsalle sai ma'aikatansu guda biyu suka zo su da kai ɗin da kuma wani buhu na buwa da shi buhun kuma akwai wani abu a cikin buhun, wannan abun kuma shine zai bayani a kai kamar haka.
And I carried out the test and the test proved positive for cannabis sativa, weighing 1.3 kg, my lord.
Wannan abun da aka samu, wannan abun cikin buhu an duba sai aka tabbatar cewa wannan abun tabar wiwi ne, wanda nauyin sai aka yi kilogram 1.3.
Just later, I crossed exhibit form, namely certificates of test analysis, packing of substance form, request for scientific aid form, and wide transparent evidence form, my lord. I fill the necessary column. The witness officer also fill their column, and the suspect thumbprinted on the form, my lord.
Sannan ya ce akwai wasu takardu kuma na shaida da ya fidda ya ba ku. Sai wabu ya ba ofisoshin nasu wanda suka kawo suka sa hannu. Kai ma kuma ka ba ka dangwala hannunka. Su kuma suka yi signing duka kamar haka.
Then I took a sample of one of the block and put in the white transparent evidence forms, my lord, and still it in the presence of the defender and the witness officer, my lord.
Sannan ya ɗibi wani samfuri a gabanka a cikin leda da ake in aka zuba da a rufe ta bakinta a gabanka aka ɗauka saboda da aka yi ainihin gudanar da bincike babba.
Where the bottle exhibit was kept in an exhibit room for safekeeping, my lord.
Sannan sauran kuma wannan kayayyakin an ajiye shi a ɗakin ajiya nasu na kayayyaki.
And the forensic is not yet ready, my lord.
Sannan sakamakon bai zo ba.
Thank you.
Mr. Bagul Davis?
Yes, my lord.
Are you done? Are you done?
Are you done?
Yes, my lord.
Thank you very much. You just informed this court that you kept the bulk of exhibit in your custody for safekeeping. Am I correct?
Yes, my lord.
Can you tell this court how you can identify the said bulk of exhibit?
Yes, my lord. On the book of exhibit, the book of exhibit, the black sack, brown, containing 2 compressed blocks of dry weed suspected to be cannabis sativa. And the name of the defender is written on the book of the exhibit, the NDLA case file number, the weight of the exhibit. Thank you, my lord.
Ya ce wannan kayayyakin da suka gudanar da binciken suka ajiye a ɗakin ajiyar yanzu zai iya tabbatar da shi. Ya ce ya ce da menene sai ya ce akwai suna da aka bayar dama an samu ana bada suna a jiki sun rubuta suna da komai a jikin buhu sannan kuma da akwai shi ainihin abun yana nan yanzu haka zai gabatar a gaban kotu.
Kindly bring forward the said bulk of exhibit for identification.
Ya ce zai iya ɗaukowa ya gabatar a gaban kotu saboda a tabbatar.
My lord, we apply for the witness to open the said cement sack to ascertain what it contains, my lord.
Go ahead.
Now, this is the book of the exhibit. The 2 compressed blocks wrapped with the white sellotape, my lord.
Thank you very much. You remember you informed this court that you issued some exhibit forms where you filled the necessary columns together with the witness and arresting officer, as well as the defendant equally affix his thumbprint on the said documents. This document, you said they includes the certificate of the test analysis, packing of the substance form, and the request for scientific aid form. Am I correct?
Yes, my lord.
Can you tell this honorable court if you see the copy of the said document, will you be able to identify it?
My lord, all the documents written on the document, the name of the defendant, and the witness officer, my lord.
Thank you very much. Please have a good look at the screen. Are these the document you are talking about?
Yes, my lord.
Thank you. Is this the copy of the request for scientific aid form?
Yes, my lord.
Thank you very much. Thank you. My lord, in these circumstances, we sought to tender the copy of the packing of the substance form, certificate of the test analysis, request for scientific aid form, and the bulk of exhibit in evidence before this court. Thank you, my lord.
Can you interpret to the defendant?
Yes, my lord. Bayan gabatar da wannan kayan a gaban kotu, sannan kuma shi lauya mai shigar da ƙara ya yi tambaya a shi saida kamar yadda saida ya amsa masa. Ya ce masa akwai wasu fom da ya cika. Zai iya gane su, ya ce zai gane saboda akwai suna da kuma sa hannu a jiki naka. Lalle da aka daga mar ya gani kuma ya tabbatar hakan su ɗin ne wannan fom ɗin. Shi ne abin da
Following exhibits hereby admitted into evidence. The exhibit form, certificate of test analysis form, packing of substance form, the request for scientific aid form are hereby marked as NDLA Mohammed 1A, 1B, and 1C respectively. The bulk of the exhibit of 2 compressed block of dried weeds confirmed to be cannabis sativa concealed inside a boa white sack weighing 1.3 kilograms, hereby marked as NDLA Mohammed Goni 2.
Ascot, please, my lord.
Ascot, please.
Sannan wannan
My lord,
takardun
that's all for the review of fact, my lord.
ya ce kotu ta ɗauka a matsayin shaida, kotu ta ɗauka a matsayin shaida.
Ask the defendant if he has any questions to ask the witness.
Kana da wata tambaya da aka yi a wannan shaida ne? Ka ɗaga murya ka kai magana.
Ask the defendant whether the facts are stated by the prosecution and the exhibit officer as presented, as well as the exhibits, reflect the true position of the matter.
Ta ce a tambaye ka wai wannan abin da shaida ya gabatar da shaida da aka gabatar da abubuwan da aka gabatar a gaban kotu. Aka ce a tambaye ka da wannan ɗin kayayyakin da aka samu da su shaida da shi lauya mai gabatar da ƙarar duka ko kana da wani ja a kai?
I wanted to know if that is the true reflection of the matter. Anyway, maybe that is your own way of.
My lord, we apply for the witness to be discharged from the witness box.
Application granted. Thank you, officer.
My lord, we equally apply for the defendant to be convicted as charged.
Yana buƙatar kotu ta hukunta ka akan abin da aka gabatar da.
Ask the defendant whether he has any cause to show why he should not be convicted as charged.
Kotu ta ce a tambaye ka ko kana da wani dalilin da yasa ba za a hukunta ka ba?
Babu.
The defendant, who indicated that he was not literate in English language, had the charge read and interpreted to him through a sworn interpreter. He pleaded guilty to the 2 counts in the charge. The learned prosecutor indicated his intention to conduct a review of the facts, which was done. I've listened to the learned prosecutor, Usman Bamala Esquire, who has produced certain documentary and real exhibits, which have been admitted in evidence. The defendant, who on arraignment pleaded guilty to the charge, has not produced any evidence of lawful possession of Exhibit Muhammad Goni 2. I am satisfied against his plea of guilty and scientific proofs of Muhammad Goni 1A, 1B, and 1C that the case against the defendant has been proved beyond reasonable doubt, as is required by sections 137 and 138 of the Evidence Act 2011. In view of the plea of guilty entered by the defendant and in line with the provisions of sections 274(1) and 2 and 356(1) and 2 of the Administration of Criminal Justice Act 2015, this court hereby finds the defendant, Muhammad Goni, guilty of knowingly without lawful authority possessing cannabis sativa, a drug similar to cocaine, heroin, LSD, and by which act he committed an offense contrary to and punishable under Section 19 and 11B of NDLA Act and 30 laws of the Federation of Nigeria. The defendant is hereby found guilty and convicted as charged.
My Lord, the convict has no previous record of conviction, and my Lord, the convict have not stressed this court to undergo any rigorous trial, my Lord. My Lord, we urge my Lord to temper justice with mercy. Thank you very much. Yes, my Lord, I can see you. You are just free. Free, yes, my Lord.
gabatar da ƙara wacce ta tambaye shi cewa ka taɓa aikata wani laifi makamanci wanda ya ce a baka da wani rekod na aikata wani laifi irin wannan.
Counsel, you are submitting.
My Lord, the convict has no previous record of conviction. My Lord,
irin wannan laifin a baya wanda aka tambaye shi yanzu ya faɗa shi ya ce ba taɓa kama ka da shi yanzu ne na farko.
my Lord, consider and so also the amount of exhibits found in possession of the convict, my Lord, is not much in number. Though 1.3, we urge my Lord to temper justice with mercy. Thank you very much, my Lord.
Ce kotu ta dubi da abin da aka samu wajen naka bashi da yawa.
Does he have anything to say to the court, the convict?
kafin a hukunta ka akwai wani abu da za ka yi a kotu ne? Daga muryanka.
Ina neman alfarma kotu mai girma mai shari'a. Ni maraya ne, ina da ƙanne, ni da kula da su, a zuwa taimaka min mun sassauci wannan hukunci.
Malam Salisu minti ɗaya.
To, my lord. Let's go, please, my lord.
Because the challenge is yes, let him continue.
Let's go, please.
Let him continue. He was let him continue.
Yawwa, ka ci gaba da kamar yadda kake faɗa.
Abubuwa, kotu mai girma mai daraja ta sassauta ta mun hukunci.
Is that it?
Semi, ka ci gaba.
Is that it?
Shikenan. Malam, that's all.
Why is he into this business?
Me yasa aka ganka a cikin wannan sana'a? Ka daga maganan ka tana ji, ba ni ba ka yi.
Jarabawa ne ya hajiya mai girma, Allah ya yarda da wannan ya riga wani ƙara faruwa ba.
From the amount, it's not a novice. What does he do for a living?
A ina kake da zama?
What does he do for a living?
Wane irin sana'a kake a inda kake?
Mashin na geja.
Ka daga muryanka sosai.
Mashin na geja.
The quantity of the dried meat recovered from his possession was about 1.3 kilograms, and it's a considerable amount. That quantity, it may not be enormous, but it's quite considerable, which certainly betrayed him as a commercial dealer, endangering the society in general by such nefarious business activities. I'm left with the impression that in this illicit trade, judging by the quantity of the dried meat recovered from the convicts, betrayed him as an old hand. It is to be noted that the offense for which the convict was arrested relates to possessing cannabis sativa, and such offenses are very serious offenses, particularly in this era of insecurity. If the convict is one of such devious businessmen, he should desist forthwith. As a young man with a promising future, he should engage himself in legal business that will contribute to the development of the society, not to engage in such disgraceful activities that will destroy the society he lives and get his sustenance from. This honorable court encourages the convict to turn over to a new leaf and be reformed. Consequently, having regard to the considerations which are analyzed are factors which ought to inform the sentence which this court will pass, and the final analysis. I hereby sentence you, Mohammed Goni, to 20 months imprisonment for the first count, 20 months imprisonment for the second count, for the offenses you have been convicted of, to commence from date of arraignment. This is to run concurrently. This is to serve punishment to you and a deterrent to others. This honorable court admonishes you to stay away from crime or any of its appearances. Essentially, the essence of punishment is to obtain a reformation in the subject. You are enjoined to stay true to your words and get exemplary life after serving your sentence. The exits found in the possession of the convicts are to return to the NDLEA to be destroyed. Convict has 20 days within which to appeal both the conviction and sentence if he's not satisfied with same.
Ascot please, yau ne kotu ta gabatar da hukunci kamar haka, inda tuhuma biyu ne. Tuhuma ta farko dai kotu ta ɗauke ka wata 20, tuhuma ta biyu ma wata 20, kamar yadda kotu ta tabbatar. Kuma sannan ta ce wannan gida da kake ciki, in kai wannan zaman ka gama ka koma cikin jama'a sai ka zamo ka kiyaye makamancin irin wannan laifin da ka yi na yanzu din. Sannan kuma ta ce kana da hurumi in kaga hukuncin da aka yi ma bai game ka ba, ka ɗaukaka ƙara a kotun gaba daga nan zuwa kwana 90. Ascot please, my lord.
Thank you, Mr. Simon. Please call the next case. Do we still have any correctional cases?
Yes, my lord, we have
minimum one.
Yes, my lord, we have one.
Yeah. Yes, go ahead, call the case. Well, did you hear that?
Yes, my lord, we did hear.
Saleh Ali.
Yes, sir. Yes, my lord. The defendant is present here at the correction center, my lord.
What? The presentation. representation. No council. No prosecuting, no defense counsel. It has a defense counsel. Okay. Unfortunately, none of the council are online, so this matter will have to be adjourned. Date. It's 21st, I think will be better. Excuse me. Alhamdulillah. This matter is hereby adjourned to the 21st day of November, 2024 for further mention. Matter is to proceedings by virtual mode.
That's good.
Because no prosecuting or defense counsel present. Inform the defendant that there's no prosecuting or defense counsel. Man Salisu, thank you so much for your services. Thank you, really appreciate. Correctional Center, thank you so much. And I would like to condole you on the demise of Malam Ibrahim.
Thank you.
Okay.
Thank you, Mama.
Thank you. Correctional officer, can you hear me?
Allah saki gama lafiya. Allah saki gama lafiya. Allah muke.
Correctional Center, can you hear me?
Yes, my lord. Yes, my lord.
Yes, I said I wanted to condole you on the demise of Malam Ibrahim, one of your staff.
Yes, my lord. We are grateful, my lord.
Okay, so sorry.
We are
His
grateful.
soul rest in peace, and convey my condolences to the other staff.
As God pleases, my lord.
Thank you so much. Thank you so much, the staff of the Federal High Court, for your assistance.
Thank you very much, my lord. Thank you very much.